Please, Your Lordship. My Lord, I have taken instructions. Lord, out of all the questions, my Lord, 2 questions, Lord, I was to take instructions. A, whether a writ petition would lie at the behest of the state government under Article 32, read with 226. And second, the scope and ambit of Article 361 in the context in which Your Lordships are, my Lord, examining the issue. My Lord, the Honorable President would like Your Lordship's opinion on that, my Lords. And there are reasons. Your Lordships are aware the opinion will be requested when a question has arisen or when a question is likely to arise. My Lord, these are the two contingencies under which, my Lord, inter alia, the Honorable President can, my Lord, seek Your Lordship's opinion on that. Please have a look at, my Lord, how this question has arisen but will definitely arise. And I am showing the view in Tamil Nadu, my Lord. I am conscious it's not an intra-court appeal, but it's a view decided and legal view Your Lordships can, my Lord, as held in the 2G case, interfere with. My Lord, please have a look at, my Lord, first, page 12509, volume 5.31. My Lord, examine this. We went to this.
The question is whether a petition under Article
32 or 226 would be maintainable in the context of the power or function, my Lord. Power is a little harsher word. Function exercised respectively by the Honorable President of India and the Honorable Governor under Article 111, Article 200 and Article 201 of the Constitution of India.
An exercise by President or Governor.
Governor respectively under Article 111 and 201 and by the Governor under Article 200. But this, my Lord, was not, my Lord, none of us assisted Your Lordships on this. And I'm the only one, my Lord, who is going to make submissions on this. Others, my Lord, would not trouble Your Lordships, my Lords.
What is the page that you have referred to just now?
12509.
That's it.
Para 367. Lord, PDF would be 336. In that volume, my Lord.
Paragraph 367.
367.
Yes.
The Honorable Bench is pleased to summarize the conclusions. Kindly come to A. Because this will have to be examined, my Lord. Otherwise, my Lord, questions will keep on arising. Which question is already, my Lord, put for Your Lordship's kind opinion. Your Lordships, may I read, my Lord? A. Where the Governor reserves a bill for the consideration of the President in his own discretion and contrary to the aid and advice tendered by him by the State Council of Ministers, it shall be open to the state government to assail such an action before the appropriate High Court or this court. Such a challenge can broadly be made on the following grounds. So first, it can be a 32, it can be a 226 petition, and these are the grounds. Please read. Where the reservation is on the ground that the bill is of a description falling under the second proviso to Article 200, it may be assailed on the ground that the bill or any provision thereof does not so derogate from the powers of the High Court so as to endanger the position which the court is designed by the Constitution to fill. The Governor, while reserving a bill on this count, shall be expected to provide clear reasons and also point to the specific provisions of the bill which, in his opinion, attract the second proviso. This is a difficult part. This question, being purely of a legal nature, would be completely justiciable. Meaning thereby the legal view is whichever is legal question is justiciable question. I'll come to that, my lords. And the competent court would be after a proper adjudication, fully authorized to approve or disapprove such reservation by the governor. If such a challenge finds favor with the competent court, then, subject to other considerations, it would be a fit case for the issuance of a writ in the nature of mandamus to the governor for appropriate action. I'll come to that, my lord, whether a writ would lie against the governor, my lord, under the scheme of the constitution. When your lordship examines governor's function or exercise of power under 356, my lord, presidential rule, failure of law and order, Article 356 provides for a contingency, that if there is a failure of law and order,
Conditions on which the power can be exercised.
power can be exercised, and your lordships would not be issuing a mandamus to the governor. Your lordships would be setting aside the order whereby the president's rule was imposed. Lord, further, then Roman 2, where the reservation is on account of the bill attracting any provision of the constitution whereas the assent of the president is a condition precedent for the proper enactment and enforceability of such a bill as a law, such as under Article 364A2, or for the purpose of securing any immunity or overcoming any repugnancy that may exist qua a central legislation, then the governor is expected to make a specific and clear reference to the president, properly indicating the reasons for such reservation and inviting his attention, that is president's attention, as described in Kesare-Hind. Such a reservation can be assailed by the state government if the reference made by the governor either fails to indicate the reasons for such reservation as discussed above, or, please mark, the reasons indicated are wholly irrelevant, mala fide, arbitrary, unnecessary, or motivated by extraneous considerations. So not only petition would lie on these grounds, and when petition is filed, these are the considerations, even unnecessary, that it was not necessary. We feel it was not necessary, so we substitute our decision to that of the governor and direct the governor by a writ of mandamus. Further, then such a reservation would be liable to be set aside. This question, being purely a legal nature, would be completely justiciable, and the competent court would be, after a proper adjudication, fully authorized to approve or disapprove of such reservation by the governor. Meaning, thereby, my lord, again, law is, if something is legal, it is justiciable. If such a challenge finds favor with the competent court, then, subject to any other considerations, it would be a fit case for issuance of a writ in the nature of mandamus to the governor for appropriate action. So, my lord, it is kind of a advance ruling, my lord. Now, my lord, kindly see 12582 or 578, 12578. One two five seven eight. My lord, I'm sorry, 12513, my lord, my lord. If I, kindly, my lord, see 12513. My lord, there is a time limit prescribed, and my lord, kindly see 12513, my lord, Roman 5. Doesn't my lord Justice Narasimha gets, my lords get, where the governor exhibits inaction in making a decision when a bill is presented to him for assent under Article 200, and such inaction exceeds the time limit as has been prescribed by us in para 250 of this judgment, then it shall be open to the state government to seek a writ of mandamus from a competent court against the governor, directing expeditious decision on the concerned bill, as is the mandate of the Constitution. However, it is clarified that governor may successfully resist such a challenge on providing sufficient explanation for the delay caused. Lord, governor can't even be called upon, my lord. My lord, here, my lord, in substance, my lord, the court doesn't use the way in which, my lord, I am describing it, that Mr. President, you decide within 3 months. You better give your reasons, my lord. I have shown that. And the state government, if she doesn't do it, come to us. That, my lord, with profound respect, is not the constitutional scheme. A, 32 does not lie. 2, mandamus cannot be issued. And 3, it is not justiciable. Every question which is legal is not justiciable. Now, my lord, come to page 12578. My lord, this will have a far-reaching ramification. Therefore, my lord, after considered debate, my lord, at our end, my lord, the Honorable President decided that it's better that we know what is the legal position, and therefore we must request for the opinion of your lordships. My lord, 12578, para A, Roman 1. These are also, my lord, the penultimate para. These are the final directions, where the reservation is on the ground that the bill is of a description falling under, that is, my lord, the same thing. And, my lord, I'll not, same conclusions, my lord, are repeated. My lord, in the final chapter, my lord. I'll just, my lord, place my short note. And my lord, I can assure your lordships, I'll not read everything. My copies are given, my lord. I have prepared this. Lord, it would be volume 1.8. Lord, volume 1 should have been the Learned Attorney General's volume, but since mine was filed first in point of time, Lord, the numbering is accordingly given. Well, I'll just broadly indicate and read only those paras which would assist your lordships, my lord, directly. Everything, my lord, is there, my lord, for your lordships to consider, and everything will assist your lordships. But, my lord, considering that I am, my lord, raising this issue with your lordship's permission at the end, and nobody else is going to, my lord, raise this issue, my lord. This is our collective work, my lord, which I am presenting before your lordships. My lord, first, whether a writ petition under Article 32 would lie at the behest of the state government, my lords. Lord, there are two objections, and based upon which, my lord, we request your lordship's opinion whether your lordships would entrust or empower the state government to file a writ petition, my lord, because you have to seek source of your right. This is the court given right, my lord, that you all right, you come to us. My lord, there are two objections. A, 32 lies when there is a violation of fundamental rights, and the state government as a constitutionally formed body per se cannot have fundamental rights. It may represent fundamental rights of others, but otherwise the scheme of the constitution is state government is repository of functions which is to protect the fundamental rights of everyone. Lord, a similar question arose even by an individual. My lord, what happened was the house was prorogued by the speaker, which was illegal. And one member of parliament approached your lordships under Article 32 of the Constitution, and the question squarely arose whether a 32 petition would lie. My lord, please come to, my lord, page 3 of my note. My lord, the bottom is the pagination. My lord, your lordships may bear one factor in mind, my lord. Kindly, my lord, this was, my lord, highlighted, but my lord, I feel, my lord, it could not be highlighted as much as we wanted to highlight it. My lord, there are chapters under the Constitution. Your lordships would find chapter 200, article 200 in the chapter which starts with legislative procedure. So please come to 196, my lord, article 196. 196, just above that, heading, my lords. 196, provisions as to introduction and passing of the bills. I'm not reading it. The legislative process starts with introduction of the bill. Obviously, it's a part of the legislative process. Then it goes up to Article 200. The legislative process culminates, ends when the governor discharges one of his choices out of the four, or the Honorable President, on being reserved, exercise the proceedings, exercise the choices under Article 201. So Article 196 to 201 is a part of the legislative process. It has as much sanctity as proceedings in the House before in the House. And thereafter, the new chapter starts, procedure in financial matters. When a bill is involving issues with regard to financial bill, etc., etc. So, my lord, my first respectful submission for your lordship's assistance is that it is a part of a legislative process, and the question would be, can any part of it be subjected to writ jurisdiction on the ground that fundamental rights are violated? Please have a look at page 721. The bottom pagination internal is 3. Ramdas Athavale versus Union of India. It was held that the validity of the speaker's decision adjourning the House sine die and later directing to resume.
Where are you reading?
Lord, I'm sorry, page 721. My note,
Yes.
top pagination is 721.
Ramdas Athavale.
Ramdas Athavale. What is 5? Yes, madam. It was held that the validity of the speaker's decision adjourning the House sine die and later directing to resume its sittings cannot be inquired into on the ground of irregularity of procedure. The relevant paragraphs reads as under. It is equally well settled that Article 32 of the Constitution guarantees the right to a constitutional remedy and relates only to the enforcement of the right conferred by Part 3 of the Constitution, and unless a question of enforcement of a fundamental right arises, Article 32 does not apply. It is well settled that no petition under Article 32 is maintainable unless it is shown that the petitioner has some fundamental right. In so-and-so versus so-and-so, this court has made a pertinent observation that when a person complains and claims that there is a violation of law, it does not automatically involve breach of fundamental right. My lord, similar judgment is, my lord, I'm not, my lord, reading it, but where they say even private party cannot come directly to the court under 32, that there is a violation of law, because you will have to show
Unless there is a
violation of fundamental rights, my lord. My lord, kindly see, Lord, one provision of a constitution can bar jurisdiction of the High Court or the Supreme Court in another provision of the same constitution. Lord, that question arose when state of Karnataka came here in a 32 petition with regard to water dispute. And this honorable court was pleased to say that we have a separate article, Article 262, for dealing with intrastate water disputes. And therefore, you cannot come under 32. My lord, please come to 722. I am also saying 131 would also not apply, but I would, my lord, come at the end. Lord, please see, there are, my lord, this is Atmaling Reddy versus Union of India, where he was a man, my lord, according to, my lord, it appears, my lord, sponsored by, not sponsored, but put up by the state. Article 131 of the Constitution, which enables the central government or a state government to institute a suit in this court on its original side in certain cases, also cannot be invoked in interstate water disputes in view of Section 11 of the Act. In other words, the provisions of Article 131 of the Constitution have to be construed harmoniously subject to provisions of Article 262 of the Constitution. A petition under Article 32, hence, cannot be entertained by this court. Well, this is only for the limited purpose that one constitutional provision can also bar jurisdiction under Article 32. Now, my lords, may kindly come to para 7. Lord, the possible argument that we are coming here in a representative capacity because we represent the people. It's a quite possible argument and a permissible argument. They do represent a wish of the people. But question is, would that entitle them to invoke your lordship's jurisdiction under Article 32 of the Constitution? Because as I have already said, the solution lies elsewhere. 32 would not be maintainable. I am only on maintainability. Please have a look at para 7. It is submitted that Article 32 is a remedial provision meant for enforcement of fundamental rights under Part 3. A state is itself the state within the meaning of Article 12 and is the bearer of constitutional duties, not the holder of Part 3 rights. Therefore, a state cannot maintain a petition under 32. For the same reason, a state cannot use 32 to litigate fundamental rights in a representative capacity. Article 32 requires the petitioner's own Part 3 right to be in issue. So that's how article is worded, that petitioner's fundamental right. My lord, your lordships have exempted this only when the concerned petitioner is unable to approach. My lord, workers,
On account of social and economic disparities.
economic, my lord, and not to the government. Government cannot come. It's the duty of the government to protect them. Some non-governmental organization comes, some individual in a representative capacity comes. Now, please, my lord, come to directly page 725. My lord, I have cited judgments, my lord. I'm not reading them. Relevant part is highlighted. Sorry. Yes, but 725. Lord, I have said that, Lord, kindly, I'll read para 13, my lords. In view of the above, a state which does not have any fundamental rights cannot file a petition under Article 32 for any purpose whatsoever. Permitting states to file Article 32 would amount to turning the scheme of Part 3 on its head. The center-state relationship is governed by Part 9, 10, 11, 12, and 13 of the Constitution. The disputes between the governments are dealt with in Article 131 of the Constitution. A state government or even the central government cannot invoke Article 32. But this would be very, very relevant. Kindly imagine a converse situation. Look, there is a law and order situation in one particular state, and such instances have arisen. My lord, I am not giving a hypothetical example, but without naming the state, where there is eruption of my lord, violence. The local police is unable to contain violence, either because of inefficiency or because of inadequacy of the force or for various, my lord, other reasons. And if the central government says, and which it can say, my lord, under the Constitution, that you deploy paramilitary forces for protecting the fundamental rights of the citizens, and the state refuses to do that. Lord, I am putting a question to myself, can the central government file a petition under Article 32 seeking a direction of your lordships, directing the state government to deploy paramilitary forces, my lord? My answer would be, my lord, in the negative. It cannot be done. Yes. No, he is rejecting my submission, my lord. So I'm saying, please don't do that. You will oppose every submission, but not now. They're simultaneous. Lord, now, Lord,
Yes, proceed.
he can never, my lord, disturb me without my consent. I refuse to be disturbed. Lord, page
Why are you getting-
725. Lord, bottom, Lord, this is.
Why are you getting disturbed if you can't be disturbed?
No, I'm just telling him that please don't do this. 725, my lord.
Yes.
Lord, this is American law, my lord, which I generally do not cite, but please have a look at, my lord, this. And therefore, I have not quoted in extenso.
Para?
My lord, at the footnote of page 725.
Okay.
In American constitution law, it is settled law that the states cannot assert the rights of their citizens as parens patria and approach the Honorable Supreme Court of the United States under its original jurisdiction when the defendant is the federal government. My lord, states there, my lord, are quite independent. It's not a part of a federal whole. They have their constitution, they have their separate flags, they have their separate Supreme Court. They say that these are federal issues between the state and the center, and we would not kind of work as a headmaster between two fighting students. In main submissions, my lord, I ignored that, my lord, but we have cited American cases also, that where the federalism is of a different nature. There were questions of deployment of forces, my lord, in American courts. But they say that you cannot come to the Supreme Court for this. These are federal issues decided politically. We would steer away from such issues being examined at the judicial level. Now, my lord, para 17, I have said, my lord, and I'll orally paraphrase, I will not read it. My lord, I am coming now to Article 226. My lord, what would Article 226 entitle or empower the High Court to do? And let us examine each. Writ of habeas corpus, no question from in the facts of the case. Writ of certiorari it applies to, my lord, tribunals, quasi-judicial bodies, etc. Writ of prohibition, when some statutory authority is discharging some function or constitutional authority is discharging some statutory function, non-constitutional function, in a manner which it should not, then it will be prohibited. The question cannot arise in the context of Article 111, 200 and 201. Quo warranto is not a situation, then only remedy left is mandamus. Now, kindly examine a situation, my lord, and take each of the options available to the governor. If he grants assent, can someone who is aggrieved by grant of assent, state would not be aggrieved, but someone aggrieved by grant of assent, can he challenge before your lordships, and can High Court issue a mandamus that assent is bad? Because then you are examining a law.
No, that is a totally different situation.
Then you will
Because
set the law.
Once a law, after the assent is granted, the law stands enacted.
So the law will be challenged, not the assent.
So the validity of the law
Yes,
can be
exactly.
challenged
I'm grateful.
on the grounds parameter available to it.
Correct.
But that's a different situation. But the question is when the honorable governor sits for a bill passed by legislature, and maybe on the second occasion also, can he just sit on for time immemorial?
I have already argued that, my lords, because justification will not confer jurisdiction. If it is not justiciable, it is not justiciable. My lord, and therefore, please, my lord, at the cost of repetition, I am urging few facts which are, my lord, only few facts are before your lordships. They, my lord, chose not to, my lord, undertake any political process. Otherwise, my lord, every state.
The Constitution debate show that earlier, before as soon as possible, the word used was within 6 weeks.
Correct, in the proviso.
And thereafter, one of the honorable members suggested, you don't look at that side. You are addressing us, not them.
No, he is behaving.
According to him, you are Hari Vishnu Kamath.
And he is so much agitated that he replies to every contention sitting there in my hearing.
No idea as to how this court functions.
Anyway,
I know.
that No, that's.
I know, my lord, because I would not prepare.
Anyway,
I
we are not supposed to resolve that dispute here.
No, my lord, that's.
We are sitting in a presidential reference.
Lord, my
You-
learned friend is right.
At 1 o'clock, both of you go for a cup of coffee and resolve
No,
it.
my lord, we can even have a meal. There is no difficulty, but I agree. I do not have any idea as to how the courts function
Anyway.
because I do not make reels and make it viral that how beautifully and brilliantly
let's stop at
I
that.
argued this. But leave it at that, my lord. It would not be proper, my lord,
So-
to be personal.
As you see
Now,
the-
my lord,
if
your
you
lordship.
see the debate, the earlier suggestion was that it should be within a period of 6 weeks. Then it was found that the time bound rule may not be appropriate. And therefore it was made as soon as possible. And one of the members also made a in discussion said that the very purpose of using the word is as soon as possible means immediately,
Earliest,
without any delay,
at the earliest.
at the earliest. And therefore the suggestion was as soon as possible, but not later than 6 weeks.
Understood. my lord. I bow
That
down.
also was not accepted.
I bow down and
So
therefore,
therefore, the constituent members of the Constituent Assembly had they in their mind was that the Honorable Governor would
is
look at the issue
expected to
with
decide
the
at the earliest.
expected exigency.
Very
And if that was the intention of the constitution makers, can we ignore that?
Lord, again, my lord, with respect, my lord, I'll put it a little, my lord.
You won't disagree that while interpreting the provisions of the constitution, we can go into the constitutional debates.
Certainly, I am relying upon, they are relying upon, everyone is relying upon. There cannot be any argument. But, my lord, the example which your lordships are giving and very rightly giving would mean that the governor is expected to react immediately. But we do
Not
not
immediately, but within a reasonable period.
reasonable period, my lord. I'm not on the time limit. But sometimes, my lord, what is that time limit, my lord? That depend upon facts
It
of
depends
each
on facts.
case.
It would
And your
depend upon
lordship-
circumstances.
Yes.
So whether the court would not be justified to find out whether the circumstances were correct or not, or the governor, I won't use the words which are used by the division bench, but was not justifiably or was not justified in setting out the bill for 6 months or 1 year.
My lord, again, I'm going back to my earlier argument and I'm not going to repeat it, my lords, that one constitutional co-organ not discharging its duties or not discharging in time will not confer jurisdiction on another constitutional organ.
Yes, we recollect your argument that if this court doesn't decide a matter for 10 years, would the president be justified in issuing an order?
It was an example given. It was not, my lord, an argument that justification cannot confer jurisdiction. Lord, it is expected, and if that happens, the solution lies outside the court rather than
That
advising the
is-
state to file petitions. That's, my lord, the respectful submission. Now, my lord, what would your lordships do? My lord, suppose it is withheld. If it is an assent, your lordships would examine the bill. But there is a possibility that assent is granted. Forget the delay part. I'm not on delay part. Assent is granted immediately. Someone is.
Then it becomes a law.
Give me a minute more, my lord. It becomes a law, and law can be challenged on various grounds: repugnancy, fundamental
On
rights.
limited grounds.
What,
On the limited grounds that are available.
whatever, my lord, it's a law is settled, and I'm not going into it. But, my lord, there can be instances where, kindly, my lord, consider this argument a little minutely. Lord, suppose the outgoing ministry at the fag end of their tenure passes a law hurriedly. I'm giving an example. The governor grants assents. The new ministry comes and new ministry challenges the assent. Lord, I am giving a hypothetical example. What mandamus the court can issue? Would the court be able to say,
The new government comes, it's always available for the legislature to change the law.
I'll come to the second point. I'll come to the second option. My lord, suppose the bill is withheld. And withheld means, my lord, as we have understood, it falls through. That withholding is challenged. And if your lordship finds, and if your lordship says that your lordship would have the jurisdiction, that it should not have been withheld, your lordships will have to necessarily say that we set aside the order of withholding and issuing a mandamus for the governor either to assent the bill or refer it to the president. Lord, the question for your lordship's opinion is, can such a mandamus be issued? Suppose the division bench says that even if it is referred to the president, a party can come here, the state can come here, not party. State can come here, that it is wrongly referred for the consideration of the president under the first proviso. My lord, would your lordships, my lord, I am posing a question to myself in a 226 or 32, say that no, it is wrongly referred, and therefore we set aside that order of referring it to the president and we direct by way of a mandamus to grant assent to the bill. Your lordships have said time immemorial, my lord, time after time, judgment after judgment, your lordships will not issue a mandamus to implement a particular law or make a particular law. Mandamus directing issuance or directing grant of assent would necessarily, inevitably mean that your lordships are directing making of the law. My lord, in A.K. Roy, your lordships have said that even if the constitutional amendment is passed by the parliament, not brought into force, a petition was filed, the court said, this is not our domain. We cannot ask them to implement this particular law. My lord, this position would be no different. Your lordships, if there is an availability of mandamus, will have to say either under Article 32 or 226 that I set aside the order of withhold, meaning thereby you decide it, you grant assent, or you refer it to the president, and that reference also is a subject matter of challenge before this honorable court, and the states would be advised to file a petition rather than taking any other constitutional option available. So, my lord, by very nature of the function and the position of the governor, the nature of the power conferred under Article 200, my lord, a writ of mandamus cannot be filed, and therefore 226 will not lie, my lords. That is, my lord, my respectful submission. My lord, in this context, Lord, I have cited laws that your lordships were, my lord, approach, that direct the government to make rules, direct the government to make this law. Your lordships refrain from doing that. That's not the domain of the court.
No, we even refrain from entering into the policy matters.
Exactly, my lord. Even administrative, executive policy decisions. But here your lordship will have to say that governor who cannot be joined as a party, who cannot be called upon to explain, the division bench legal view is that governor will have to come and explain that what was the delay, why he referred it to the president, what is the reason for withholding. My lord, Article 361, my lord, becomes nugatory, my lord, if your lordships accepts the state's power to file a petition, my lords. My lord, now kindly see, lord, in S.R. Bomai, I'll read only 2 paragraphs and I'm not doing anything further. But please bear one distinction in mind.
You are saying all such directions can be given under 131?
No, my lord. I'll answer that immediately.
So therefore, the issue of forum is irrelevant.
No, my lord, I'll just answer that question.
Is there a forum at all for that?
Well, that's my case. It's not just issue.
No forum. The issue of whether 226, 31, 32 was all irrelevant.
Correct, my lords.
What's the
And
matter?
I'll answer your lordship's question on 131. Why I say this? I'm sorry, my lord, the Chief Justice is reading something.
Yes.
But 131, why it would not lie? So 131 is a provision where your lordships examine and adjudicate a dispute between Union of India and the state government. Here, one party is the state government, but governor is not Union of India. He is not a representative of Union of India. He represents the Honorable President of India. And therefore, any dispute between the state government.
How do you say that he doesn't represent the government of India?
No, he represents the President of
The government of India, the executive authority vests in the president.
No, constitutionally speaking, he represents the state. He is head of the state executive, representing
As a representative of the central government.
President of India, my lord. That's
The constitutional debate says that he is a vital link between the central government and the state government.
no. Kindly, my lord, have a look at, my lord, the provision. My lord, 155. Kindly.
So if you go through the constitutional debate
Yes.
as to whether there should be a governor or should not be governor. So the framers of the constitution found that the governor has to be there so that a vital link is provided between the state government and the central government.
Kindly look at it from a different angle. I'll show 155, but a slightly different angle. is the president under Article 200 bound by the aid and advice of the central government? The answer is no. There are only two contingencies.
Central government, the president would be bound by the aid and if you.
I'm on governor. I'm on governor. Right now, I'm on governor. The governor can either decide based upon the aid and advice of Council of Ministers of the state or in his own discretion. He may represent the central government in a broad sense as understood in the Constituent Assembly debate. But he is appointed by the President of India and he is reporting and answerable to the President of India. And there are several constitutional functionaries who are appointed by the President of India, but they do not represent the central government. Please have a look at Article 155. I'm putting a question little differently. Suppose the governor's action is under challenge. Can the central government come here and start defending the governor? Cannot. Lord, in most cases, it is the state government which appears and defends the governor. And this is the constitutional reason behind it. Lord, we are not on A situation or B situation. Lord, I'm just assisting on a constitutional scheme. Lord, 155 says the 154 first, my Lord. The executive power of the state shall be vested in the governor and shall be exercised by him either directly or through officers subordinate to him. Then, my Lord, 155, the governor of a state shall be appointed by the president by warrant under his hand and seal. Lord, what is envisaged is that there would be a person who will deal with the national policy vis-a-vis the state level policy. But he is not the same thing as Union of India for the purpose of Article 131. Article 131 is central government versus state government dispute. Dispute regarding the boundary, dispute regarding the powers, dispute regarding the allocation of funds, etc., etc. Directly central government, directly state government. Because if we, my Lord, extend this logic, then even CAG is, my Lord, appointed by the President of India. Election Commission is appointed by the President.
Sir Prasad one,
Yes,
this question was slightly answered,
Yes.
saying that the actions of the government, of course, there is an immunity, but if at all he needs to answer, that answer will come through the government. Rameshwar Prasad one, not two.
Yes, my Lord, but the government of the state. Because he heads the state. My Lord, I kindly appreciate, my Lord, he can't be joined. If a mandamus were to be issued, he will have to be joined, then we will be violating Article 361. And who will defend him? The state may not, because the state is the petitioner. Central cannot, because I can't come and say that, no, he's my representative. He did it at my behest. No, that's not the constitutional scheme. Lord, kindly see, my Lord, and the question of justiciability is a separate question, my Lord. But now please come to Lord, I'll, my Lord, at the end read only few paragraphs from Bomai. But bear, my Lord, but first, my Lord, I'll read few paragraphs from Bomai. My Lord, kindly bear one factor in mind. Bomai was a case where the governor's action under Article 356 of the Constitution was impugned. Article 356 has an inbuilt condition incorporated. When can you invoke? When there is a failure of law and order. And therefore, your lordships had a test to apply whether the governor's decision fall within this constitutionally framed condition under Article 356 or not. It was not, my Lord, a constitutional decision in the sense in which, my Lord, we are respectfully submitting under Article 200. Now, my Lord, kindly have a look at, my Lord, only few paragraphs, my Lord. My Lord, volume number 5.14. Lord, Lord, your lordships may first, my Lord, take only paragraphs, my Lord, I'm giving. I'll read 2 or 3 paragraphs.
Volume?
My Lord, volume
5.14.
5.14. It starts at Lordship, give me a minute. 5478.
5478.
78. Lord, kindly note the para numbers. I'll read only 2 or 3, but all are, my lord, relevant. So Justice Ahmadi, para 32 and 35. 32 and 32 TO2 35. Then Justice Verma for himself and Justice Yogeshwar Dayal, para 40 to 49. And Justice Sawant for himself and Justice Kuldeep Singh, para 59, 60, 62, 74, 83, 86, 96, and 153. Then, my lord, Justice Ramaswamy, para 198, 201.
One minute.
I'm sorry, my lord.
Ramaswamy,
Para 198, 201, 211, 256-258. So Justice B.P. Jivan Reddy has expanded the scope of this court's jurisdiction, my lord, and said that it is amenable and there is justiciability, my lords. That is para 331, 372.
one minute.
I'm sorry, my lords. Lord, 331, 372 to 376. Lord, they are all extracted in our main note at page 305 to 308. But please read, my lord, only one paragraph of Justice Ahmadi. It's a majority view. Lord, kindly come to page 5558. So this was again, my lord, at the cost of repetition, a case of 356, where there was a binary. You can appoint or you cannot appoint precedence rule. Why? For what reason? What should be the ground? Failure of law and order. Here, my lord, we are dealing with a situation with multiple options and multitude of contingencies under which, my lord, those options are to be exercised. 35, Lord, somewhere from classitum G. The expression otherwise, your lordship gets, my lord?
Yes.
The expression otherwise is of a very wide import and cannot be restricted to material capable of being tested on principles relevant to admissibility of evidence in court of law. Now, please see, it would be difficult to predicate the nature of material which may be placed before the President or which he may have come across before taking action under Article 356(1). Because not only material provided by the governor, President can have other material also. Besides, since the President is not expected to record his reasons for his subjective satisfaction, the article doesn't say you record your reasons. That is read for the first time, my lord, in Article 200. It would be equally difficult for the court to enter the political thicket to ascertain what weighed with the President for the exercise of power under the said provision. The test laid down by this court in barium chemicals and subsequent decisions for adjudging the validity of administrative action can have no application for testing the satisfaction of the President under Article 356. It must be remembered that the power conferred by Article 356 is of an extraordinary nature to be exercised in grave emergencies, and therefore the exercise of such power cannot be equated to the power exercised in administrative law field and cannot therefore be tested by the same yardstick. Please note this, my lord, and kindly underline, several imponderables would enter consideration and govern the ultimate decision, which would be based not only on events that have preceded the decision, but would also depend on likely consequences to follow, and therefore it would be wholly incorrect to view the exercise of precedent satisfaction on par with satisfaction recorded by executive officers in exercise of administrative control. The opinion which the president would form on the basis of governor's report or otherwise would be based on his political judgment, and it is difficult to evolve judicially manageable norms for scrutinizing such political decisions. It therefore seems to me that by the very nature of things which would govern the decision making under Article 356, it is difficult to hold that the decision of the president is justiciable. My lord, it's not on the question of jurisdiction of this court, it's justiciability. And my lord, para 34, your lordships can mark, there is a marked distinction shown in the judgment only. What is the distinction between judicial review and justiciability? Something can be within your lordship's judicial review power, but can still not be justiciable. Here, my lord, we are dealing with a situation where, my lord, the law as developed says that it's a question of law and therefore it is justiciable. Now, to do so would be entering the political thicket and questioning the political wisdom which the court of law must avoid. The temptation to delve into the precedent's satisfaction may be great, but the courts would be well advised to resist the temptation for want of judicially manageable standards. Therefore, in my view, the court cannot interdict the use of constitutional power conferred on the president under Article 356 unless the same is shown to be mala fide, because it was ultimately an administrative decision, not a legislative decision, where mala fides cannot be attributed. Then, my lord, after E, classitum E, I am also in agreement with Justice Verma when he says that no quitimate action would be permissible in such cases, etc., etc., my lord. Now, my lord, kindly come to para 216, Justice Ramaswamy. My lord, rest, my lord, I am not troubling your lordships, my lord. At 5664. Your lordships, my lord, got it? Para 216. To test the satisfaction reached by the president, there is no satisfactory criteria for judicially discoverable and manageable standards that what grounds prevailed with the president to reach his subjective satisfaction. Please see under Article 201 or 111.
5645?
Lord, 5664. 5664.
16.
Yes. To test the satisfaction reached by the president, there is no satisfactory criteria for judicially discoverable and manageable standards that what grounds prevailed with the president to reach his subjective satisfaction. There may be diverse, varied, and variegated considerations for the president to reach the satisfaction. The question of satisfaction is basically a political one. Practically, it is an impossible question to adjudicate on any judicially manageable standards. Obviously, the founding fathers entrusted that power to the highest executive, the President of India, with the aid and advice of Council of Ministers. The satisfaction of the President being subjective, it is not judicially discoverable by any manageable standards, and the court would not substitute their own satisfaction for that of the President. The President's satisfaction would be the result of his comprehending in his own way the facts and circumstances relevant to the satisfaction that the government of the state cannot be carried on in accordance with the provisions of the Constitution. There may be wide range of situations and sometimes may not be enumerated, nor can there be any satisfactory criteria. But on a conspectus of the facts and circumstances, the president may reach the satisfaction that the government of the state cannot be carried on in accordance with the provisions of the constitution. Therefore, the subjective satisfaction is not justiciable on any judicially manageable standards. Moreover, the executive decision of the president receives the flavor of the legislative approval. No, that is something different because that has to go before the House. We are not concerned with this, my lord. I am relying upon this, my lord, to show that multitude of considerations go into the decision making, whether to grant assent, withhold assent, refer it to the president, or resort to the proviso. And one consideration can be to let the situation cool down. Suppose a parliament passes a law, assembly passes a law that except a particular local language, we will not permit use of any other local language. Maybe it is within list 2. And waiting for 1 year may be considered by the governor in his constitutional wisdom to be a wise thing to do. Then kindly come back to my note, my lord. I am not reading any other, my lord. My lord, I have relied upon page 720.
Much more time is required?
10 minutes.
More than 1 hour.
I'm sorry.
That's half
My
an hour.
apologies, my lord. Your lordships have been very indulgent, my lord. My apologies to my learned friends also, particularly Mr. Sibal.
Oh, we'll have to compensate that time.
I will.
We will have to compensate. Or you will compensate from your rejoinder, then it's okay.
No. But I will compensate outside the not, my lord. I can't compensate the time, my lord.
Just, if I may just have liberty for a moment.
No. May what?
I have signed it from.
That's all. Lord, I have cited AK Colmer. I am not reading it. Your lordships may kindly read it. But please, my lord, come to page 730. On the lighter side, Lord, for the first hour, Lord, we did not start arguments. First hour was on the preliminary issues raised by them. So nobody needs to be compensated. Now we are being compensated for that 1 hour which we lost. On the lighter side. Well, entirely your lordship's discretion, my lord.
So 4 days was including 1 hour for the preliminary.
Your lordships are right. I am saying on the lighter vein, my lord. Your lordships can, my lord, extend time, curtail time. My lord. That's absolutely my lord's discretion. My lord, page 730, my lord, I have cited one British judgment, my lord, which I generally do not cite, but 2 reasons. A, my lord, our writ power is, my lord, prerogative writs as was available in England. And second, our constitution is essentially and broadly framed on the British parliamentary system. My lord, only one paragraph. And, my lord, this judgment is cited in India from beginning, my lord, not in a recent time, my lord. From the beginning, and it has, my lord, it is cited with approval of this court, my lord. My lord, kindly see 731. But I do not think that the right of challenge can be unqualified. It must, I think, depend upon the subject matter to the prerogative power which is exercised. Many examples were given during the argument of prerogative powers, which, as at present advised, I do not think could properly be made the subject of judicial review. Prerogative powers such as those relating to making of treaties, the defense of realm, the prerogative of mercy, the grant of honors, dissolution of parliament, and the appointment of ministers, as well as others, are not, I think, susceptible to judicial review because their nature and subject matter is such as not to be amenable to the judicial process. Now, my lord, I have given 4 classes.
But in England, the powers of the High Court are much restricted as compared to the powers of our High Court.
Correct, my lord. Correct. They cannot even go into the question of validity of a law.
Validity of a law.
I am, my lord, on a limited point. Then there are certain prerogative functions of co-equal constitutional functionaries which would not be subjected to prerogative writs by the judiciary. My lord, that is what, my lord, this judgment says. My lord, your lordships would be guided. My lord, that's my respectful submission. My lord, by these 4 factors which I am not reading or elaborating, the authority, which authority the government is exercising under Article 200. What are the nature of its functions? Second is nature of the function. Third is the stage of the process. But your lordships are, my lord, as my lord held in the judicial view taken by the division bench, there is a permissible approach to Article 32 or 226 at a stage where the bill is yet to become law. If you come here, the withholding is wrong, grant of assent is wrong, referring is, even reference to the president is wrong. Reasons are not given. Reasons are unnecessary reasons. That's what, my lord, the view has taken. That view, your lordships may have to say correct view or a wrong view. Then constitutional choice in Article 200 is not binary. My lord, I have said, my lord, distinguishing it from Article 356. It's not that whether to appoint president rule or not to. There are several choices and multitude of contingencies to be kept in mind. Lord, one judgment, and I'll read only one part. Lord, somebody came here that criminals should not be inducted into the ministry. Lord, this honorable court, my lord, has said this at page 733. It's a 5-judgment judgment, Manoj Narula. Thus, while interpreting Article 75(1), definitely a disqualification cannot be added. However, it can always be legitimately expected, regard being had to the role of minister in Council of Ministers and keeping in view the sanctity of oath he takes, the Prime Minister, while living up to the trust reposed in him, would consider not choosing a person with criminal antecedents against whom charges have been framed for heinous or serious offences, etc. And last, rest has to be left to the wisdom of the Prime Minister. We say nothing more, nothing less. Lord, this applies with equal force to the Honorable President of India and the Governor. Then your lordships may kindly come to, my lord, Khera versus Shergill, page 734. I'll read, my lord, only the highlighted part at 734. Immediately after citing, my lord, New Zealand judgment, the distinctive feature, your lordship gets, highlighted part, my lord. The distinctive feature of all these cases is that once the forbidden area is identified, the court may not adjudicate on the matters within it, even if it is necessary to do so, in order to decide some other issue which is itself unquestionably justiciable. Where the non-justiciable issue inhibits the defense of a claim, this may make it necessary to strike out an otherwise justiciable claim on the ground that it cannot fairly be tried. If it is unjusticiable, even connected justiciable issues would also, the court would be refrained from examining. Your lordships, my lord, the chief got that, my lord?
Yes.
Yes. Lord, Article 361, my lord, this is my last point. Please come to, my lord, page 736, Rameshwar Prasad. My lord, my lords, perhaps, my lord, indicated, had in mind, para 173. Incidentally, my lord, Justice Narasimha appeared, my lord, in the matter. Para 173, my lord. Plain reading, may I read, my lord, page 737, my lord. Plain reading of the aforesaid articles show that there is a complete bar to the impleading and issue of notice to the President or the Governor, inasmuch as they are not answerable to any court for the exercise of performance of their powers and duties. Most of the actions are taken on the aid and advice of Council of Ministers. The personal immunity from answerability provided in Article 361 does not bar the challenge that may be made to their actions. Under law, such actions, including those actions where the challenge may be based on the allegations of malafide, are required to be defended by the Union of India or the state as the case may be. By Union of India means President of India and Governor means state. And we are now examining, your lordships are examining a question whether state can file a petition challenging government's action. Then there will be nobody to defend it. even in cases where personal malafidis are alleged and established, it would not be open to the governments to urge that the same cannot be satisfactorily answered because of the immunity granted. In such an eventuality, it is for the respondent defending the action to satisfy the court, either on the basis of the material on record or even filing the affidavit of the person against whom such allegations of personal malafidis are made. Article 361 does not bar filing of an affidavit if one wants to file on his own. I have my reservations, but this is the law declared, my lord, by this court. The bar is only against the power of the court to issue notice or making the president or the governor answerable. In view of the bar, the court cannot issue direction to the president or the governor for even failing to assist, filing affidavit to assist the court. Filing of an affidavit on one's own volition is one thing, then the issue of a direction by the court to file an affidavit. The personal immunity under Article 361(1) is complete, and therefore there is no question of president or the governor being made answerable to the court in respect of even charges of malafidis. I'm citing this as a judgment. As students of law, we may have our views. And, my lord, kindly see in the final conclusion, my lord, at page, my lord, 738, para 179, the position, your lordship gets one. The position in law, therefore, is that the governor enjoys complete immunity. The governor is not answerable to any court for the exercise and performance of the powers and duties of his office, or for any act done or purporting to be done by him in exercise and performance of those powers and duties. The immunity granted by Article 361 does not, however, take away the power of the court to examine the validity of the action, including on the ground of malafidis. But again, this was not in the context of his legislative function under Article 200. In a matter where he cannot be even defended by the state and will not be defended by the state. My lord, in Nabam Rebi, I am not, my lord, reading that judgment. The governor was issued notice. Lord, it was pointed out that 361 is immune. Well, this is a 7-judge bench judgment. The court withdrew the notice issued to the governor. That no, it was a mistake. We should not have issued notice to the governor. Lord, kindly come to my lord.
But he appeared on his own and filed an affidavit.
That's what the judgment also said. On his own volition, he can come.
That is, exactly 2 minutes back, I read that. Exactly 2 minutes back. And both of us appeared, we know that happened. So this social media and reels have created a problem. I'll my lord, proceed further, my lord. Please come to my lord 741. And this is my last submission, my lord. Para 41. It is submitted that the judicial pronouncement interpreting Article 361 was in the context of an action of the president or governor not relatable to either Article 111 or Article 200 or 201 of the Constitution. The cases decided by this honorable court held that government can answer on behalf of the governor. In practice, the secretary to the governor is joined as a party so as to enable the court to seek the record from the office of the governor to satisfy itself about the existence of material, procedure, etc. But in case of executive functions, here material may be available, but the satisfaction, which can be in the form of grant of assent, which can be in the form of withholding of assent, reference to the assent, or reference to the house. Lord, kindly see the devastating consequence. Suppose the governor refers it back to the house, and if 226 is maintainable, some private citizen will come that why it was referred to the house. Lord, would the honorable court, I'm posing a question to myself, start examining pre-enactment actions of the constitutional functionaries? Which is precisely, my lord, the law which is laid down. Lord, therefore, my lord, my submission is neither 32 is maintainable or 226 at the behest of the state. Number 2, even at the behest of private individuals, They are not justiciable questions, and therefore 32 and 226 would not be available. And 311 would also not, no, I'm sorry, 131 would also not be available, my lord, because it is not Union of India and the state or between two states. My lord, I have cited, my lord, BP single judgment, my lord. Because BP single, my lord, 5-judge bench says that, my lord, I'll just note the para, my lord, they are not agents of the Union of India. That's what, my lord, 5-judge bench has said. 7904,
The Union Government of the.
Lord, para 40. I'll just read, my lord. Please note the para, page number 7904, BP single, volume 5.20, page 7904, paras 40. He is not an employee of the Union government.
Page number?
7904.
Volume 514.
Yes, madam.
20, 20.
5.20 minutes.
What are the parties' name?
My lord, BP single versus Union of India. Lord, para 40. It says, my lord, he is not an employee of Union of India or agent of the party in power. So, para 40, I'll read, my lord, read it fully. It is thus evident, your lordship gets. I'm sorry, my lord, Justice Regan.
Yes.
It is thus evident that a governor has a dual role. The first is that of a constitutional head of the state, bound by the aid and advice of his council of ministers. The second is a function as a vital link between union government and the state
That's what
government,
I was
which
saying.
my lord the Chief Justice were indicating. He is a link and the state government. In certain special or emergent situations, he may also act as a special representative of the union government. In special my lord, situations, he is required to discharge the functions related to his office, different roles harmoniously, assessing the scope and ambit of each role properly. He is not an employee of the union government, nor the agent of the party in power, nor required to act under the dictates of political parties. There may be occasions when he may have to be impartial or neutral umpire where the views of union government and the state government are in conflict. His peculiar position arises from the fact that the Indian constitution is quasi-federal in character. So, my lord, if governor cannot be joined, governor cannot be made answerable, and it's a issue between union and the state, my lord, I'm putting a question to myself, my lord, who will defend the governor? If the law is right that if he doesn't do it, come to us. If the president doesn't do it, come to us. And they will have to do it in this fashion. My lord, these are my respectful submissions. I'm really grateful for the indulgence. It was an indulgence, my lord, given, my lord, by your lordship.
I'll just take a moment, Lord. Our understanding was that this issue was not being addressed, but we have, as state of Andhra Pradesh has filed a 32 Lord. Therefore, I would reserve my rights to seek instructions, Lord. If my Lord may permit at the end, I may just respond.
State of Andhra has filed 32.
There are 30, not some other issue, Lord. It's not on the issue, because in para 13,
Better take instruction.
para 13, the SG's submission is broad-based. 14 qualifies it, 60 qualified, but 13 of the submission.
I'm saying
is broad-based.
202, 201.
I'll have to take instructions. I'll have to take instructions on it. That's all. I'm not saying I want to respond to it, but I'll have to take instructions on it. At the end, I'll just ask your lordship for maybe a few minutes.
It's a proposition of law. I'm not on Telangana, even Madhya Pradesh, Rajasthan, Maharashtra, nobody can file. State of cannot file it. That's all.
You would have to take instructions as to
Certainly.
what is the stand of it.
Other issues, but we are endorsing and supporting the stand of the AG and the SG. Not this is the only.
Yes, certain.
You have seen the timetable. There are in some states there are 2 to 3 councils. We have on this side we have.
That maybe we have, my lord.
1 minute. Yes. We have when we are saying something, we don't expect.
My
When you object to his
no, I'm sorry.
in In their case, we did not allow more than one council per state.
State.
In so far as the other side is concerned, we did not permit more than one council to appear for one state. So we have to make a choice.
Lordship will follow the same.
No,
Work it out.
in case of some states, they have given names of 3, 4.
That will have to be adjusted. I'll try and work it out in the lunch first. I'll
Yes,
try
sir.
and work it out in the lunch.
They will have to choose whoever wants,
I understand.
whoever wants to represent.
Work it out in lunch.
This both will have to sort it out.
Hmm? Wait, please do, my lords. Well, is my submissions, your lordship will find in volume 2.2, starting, I am told at 470. Open it here. The actual submissions start from 480. The rest is an index.
Volume 2.2.
Volume 2.2.
Volume
Volume
2.2 starts from
Volume Roman 2.2 PDF का page अलग होगा.
PDF, you are telling the PDF page,
No,
running page.
No, running page.
Physical
Running
copy.
page.
Volume Roman 2.
Well, this is it, the way it looks like. Running page is given by lordship.
Yeah. हमारा
Roman 2.2.
I tell you, be here. I'll be here.
The link is there, though.
It's on the link also, well, it's of course hard set also. It actually starts at 480.
Yes.
When your lordship starts using it, your lordship may do me the favor of using the second page on the right side rather than the big page. It'll be easier. When your lordship uses it, lordship may use the smaller page when your lordship uses it, but I mean just for convenience. Let me, well, let's tell lordships in 2 minutes the structure and the sequence. The 3 bigger issues I'll be dealing with. The first, which starts with page 480, that is page 1, is about the whole concept of discretion, the lack of it, the degree of it, etc. in 200, Article 200. So that's the broad discretion point. That is, Balut's, I think up to pages 61 to up to 63, the smaller page 63 of my submissions. It deals with questions 1 and 2. So discretion is a lordship's presidential reference questions 1 and 2. I will then deal, Malus, with questions 3, 4, 6 and 9 collectively, which is broadly judicial review, oblique justiciability, oblique supremacy of judiciary, etc., etc. That will run from 63 to 103. And all of us quotations really, because rather than take a lordship to judgment, the relevant lines are underlined and quoted, as Mr. Mehta has done. The third broad issue, Malus, I'll deal with is the timelines, which will be from page 104 onwards in detail. And then, Malus, I'll deal very briefly with the relatively more subsidiary issues, which is question 8, 10, 11, 13 and 12. That's clubbed together towards the end of the submissions. What I have done, Malus, in structure is that on each head, for example, I'm starting with discretion. I've summarized everything I want to say on that in 2 pages in the beginning to give your lordship the sequiturs and the consequences. And the rest is an elaboration of that broadly in the same sequence. So now, Malus, if your lordship will turn to 200, which is at page 1, which is page 480, the longer page, your lordship will use the smaller page.
Page?
480, my first head starts with discretion and Article 200. And in that, Malus, in the beginning, I have given in 2 pages all the summary points, 7 points in summary of what I'm saying on discretion, just summarizing the propositions. Willis, the summary is this. First, Willis, I will deal with the fact that the governor and the president, I'm reading para 2, Willis, at page 1, are titular heads functioning within a federal parliamentary form of government, bound by their respective state and central council of ministers, with no discretion as to executive decision making, save and except where so explicitly conferred by the Constitution, that too in a few rare cases.
What about 163?
Fully dealt with once. That's fully dealt with. I'll make good that. And in each system, this is the pattern I'll follow in each, and under each also, CAD first, some case law then, and the first principles. That's directly 163.